attending this interview. Very kind to give of your valuable time. Alex is a highly experienced immigration solicitor who has worked in the space for many years and is very respected for the quality of his advice and his interest in the development of immigration and nationality law. So, Alex, what has been your career in law and what areas of immigration law and nationality law have you mostly worked in?
Well, thank you very much, Bruce. First of all, it's a pleasure to speak to you. I'll try and live up to your introduction. So I have worked in immigration pretty much full time since 2008. I initially joined a legal aid firm specialising in asylum and human rights law in southeast London. That was my first job in law after I did a training contract qualifying in 2010, seats in immigration, family, crime and housing. Qualified as a duty solicitor, which is a sort of a criminal defence accreditation, but it never sat very well with me. I think you have to be either very sympathetic to the client or have quite a strong stomach for criminal defence, and I didn't really have that. But immigration suited me right from the beginning, and I really, really enjoyed it. I generally felt that I was sympathetic to the position that my client was in, wanted to help them. So when I qualified in 2010, I went into the immigration department and spent another 3 years there, doing a lot of advocacy in the first tier and upper tribunals, still for asylum cases, deportation, and I was very pleased to do some country guidance cases and appeals to the High Court and Court of Appeal. But I was looking for a way out. There were proposals from what was then the coalition government to cut the legal aid budget and introduce something called price competitive tendering, which would sort of further decimate legal aid. And I was fortunate to do an internship at a law firm then called Speechley Bircham, now Charles Russell Speechley, and that opened my eyes, I guess, to the world of business immigration. I was with a partner there called Rose Carey, and after that I was looking for a way out, and I joined Passportia, as you know, and spent about 18 months working with you on founding that which was a OIC, which is an OIC registered consultancy focusing on ancestry-based claims to British nationality predominantly. And then in 2015 I joined Fragaman, which is a global immigration services provider headquartered in the US, in the London office. And I joined the corporate teams, working on mid to large companies on their work permit programs mainly. But personal immigration was always my interest, and in sort of late 2016 I transitioned to the private client team within Fragaman, where I was until quite recently, just last month I think. So there I was privileged to work on a number of matters that were very interesting. Obviously that encompasses quite a large span of time, including the end of free movement and the Brexit process, the launch of the latest incarnation of the points-based system, and I was lucky enough to work with many interesting clients, members of royal families, footballers, other types of celebrities, along with more cases, for example, surrogacy cases. And I was very pleased to fulfill one of my ambitions when I was a law student, which was to be involved in a SIAC case, Special Immigration Appeals Commission, which was a large-scale case we ran together with a white-collar defence firm. And then more recently, I joined Vanessa Ganguin as a senior associate, and focusing now on a mixture of personal and business immigration.
Thank you, Alex. You've had a very interesting range of immigration experience. One thing is your voluntary work in British citizenship for the Chagos Islanders. Could you say just a few words about that?
Yeah. So I think I was always aware of the issue a little bit from reading, always had an interest in international politics. But I remember you and I were speaking to Alison Harvey at a ILPA training course, and I think you asked her something along the lines of what reform would you most likely like to see in British nationality law? And I remember her saying, I'd like to do something for the Chagos Islanders. I didn't really sort of have any awareness of the issue, but I think it was in 2017, Ian Robinson, who's now a partner at Vialto, introduced me to a former colleague of hers from the Home Office who was very keen on pushing a particular amendment forward. And so I began to kind of informally act as a legal advisor in a way to that campaign, which was initially to get British overseas territory citizenship only. That was a private members bill that was put forward, I think it was 2017 or 2018, stayed in the parliamentary agenda until it got nixed when Boris Johnson prorogued Parliament. I think it was in 2019. And then in 2021, then of course, the then Home Secretary Priti Patel introduced, started to consult on a nationality bill, and I responded to that, proposing something for the Chagos Islanders, and it kind of grew from there. I was only a small piece of a much larger effort, but the main people who are responsible for that, I guess, would be Henry Smith in the Commons and Baroness in the House of Lords, whose name temporarily escapes me, but who essentially put it forward very forcefully there and managed to get an amendment to what's now, I think, Section 17H of the 2022 Nationality Act, which gives a route to British citizenship for descendants of those born on the Chagos Islands. And so, yeah, that was something I was very pleased to be involved in. And very unexpected, actually, that we got it through, because right until the very last moment, we fully expected it to be ignored. And so very sort of pleasant surprise at the end.
Well, congratulations for getting that through. And thank you to you for making the lives of many Chagosians much more secure. What are your thoughts on the evolution of UK immigration law since 2008?
So there's been a huge number of changes in that time, and I can really sort of, my answers are very focused on the situation that I've been in at the time. I mean, I experienced in the first 5 years of that period, as I say, the decimation of legal aids, and that has continued. So that it's now very difficult for, the need for legal aids advice in immigration at least the demand far outstrips the supply. So that's a growing problem. And then in the field of business immigration, the main changes, of course, I guess the two main changes have been the end of free movement, of course, and the subsequent relaxation, almost total relaxation of the work permit rules. So when I started in 2015 in business immigration, there was a resident labour market test. There was a cap on the number of out-of-country applications. There was a maximum time you could spend in the route, and other restrictions. No ownership of the business in which you were working. So various restrictions that none of which arguably were really achieving very much benefit, and all of which were essentially thrown away during the course of 2020 and the launch of the new immigration system, which radically reduced the skills thresholds to RQF 3+, much lower level than RQF 6, which it was previously, and got rid of all of those other restrictions I mentioned. And that was understandable because the government was at that time contemplating the end of our access to free movement from Europe. So that's been the biggest change in terms of policy. Together with that, there's been the move away from the civil service assessing matters and a move towards a kind of partner model. So essentially, entrepreneurial routes, there's been a huge reduction in the number of routes by which one can move to the UK. And in particular, entrepreneurial investment, business establishment routes have been largely ended. There are routes still available, but they're in many cases almost impossible to use. And instead, almost all business migration has become sponsored work permit migration. And then the other big change that's happened has been digitalization. So when I started in 2015, we were filling out paper forms, we were collecting physical documents from our clients who were submitting them in person to the Home Office. And by 2019, unfortunately, before the start of the pandemic, that process had become almost entirely digital, so that with the exception of its initial couple of month periods when the pandemic hit, it actually didn't have that much effect on the immigration field. Of course, there were massive effects, but it didn't bring things to a halt as it did in the US, where they were still reliant on paper forms. And that digitalization process was very significant and is continuing, as you'll know, with the launch this year of e-visas and ETAs. So that process continues. So those are some of the main broad trends in the immigration field that I've experienced, I should say.
Well, thank you for that. A good summing up of a topic one could talk for hours about. Now, I want to now focus on the skilled worker route, which you mentioned. How well do you think the skilled worker route has worked for British businesses since it was launched at the end of 2020?
We now, I think that it did its job. I mean, I think it's a process. It's a route that's still in evolution because, as I say, it started from a position of almost total laissez-faire, with the only real restriction, I mean, if you really want to sum up what the rules are as they were, at least in, say, 2021, the rules are essentially, well, you have to have a job, and it has to be a real job, can't be made up, and it has to be sufficiently skilled, but that's really only RQF3, so it's a very relatively low skill level. Really, the barrier is the cost to sponsor, to pay all of the immigration health surcharge, immigration skills charge, and all of the visa fees for, say, a family of 5 for 5 years up front. You could be looking at government fees of, say, £25,000, £30,000 potentially, which is, if you throw everything in, license acquisition, all in together, and that's more than the GDP per capita of many countries. So really, sponsoring a migrant worker, they have to be someone pretty valuable to business to pay that in cash up front. So that's really been the main limiting factor. And then it's evolving. So of course they've increased the salary level now to the 50th percentile as of April for paying that occupation. And we're really sort of seeing how it evolves. But immigration it's never the main focus of most businesses. It's a nice to have in most cases, and it really remains to be seen whether it sufficiently serves the needs of the UK economy. But for sure, I mean, there's many people who would want to sponsor workers who can't usually the main reason for that is it just costs too much. So that's a question of policy for government as to whether that's acceptable, or they'd rather sort of get the growth that would come with be able to bring more people in, or protect resident labour. So that's kind of a non-answer, but it's okay, just really expensive.
The expense varies, I think, quite considerably with the proposed employee and the size of the sponsor.
That's true, yeah.
How do you think the skilled workers scheme has worked out for immigration practitioners, considering all aspects?
I mean, as an immigration lawyer, I can say that I think the drafting is pretty good, actually. I was part of the Law Commission's simplification of the rules. I wasn't part of it, but I was attended some initial meetings, and I get they looked at various models, whether to kind of have a booklet approach or different kinds of approaches. I think that they went with the booklet type approach using Appendix FM as a model, but actually Appendix Skilled Work is much better than Appendix FM. It's much better drafted. When I started in 2015, you were looking at quite a variety of different places in the rules, but now you're looking in basically 2 appendices, and they're laid out pretty nicely. And then the sponsor management system, I think, has its faults for sure, and it's quite an old technology. You can't find out, for example, what entities you've linked on the licenses on a given license. You're not sure which work locations have been added to a license. So there's things like that are suboptimal. You don't know what the linked entities are from looking at the system. That can all be improved, but generally speaking, I think it's quite a simple system. It's very fast. I think if you look at government processing times, I'm sure everyone complains about them in the UK, but if you compare them to other countries, they're actually pretty good internationally. There's actually very few countries that have faster visa processing times in the UK. So overall, I would say that it's a fairly successful system, and it's not too complicated to understand.
And based on your experience, what aspects of the application process do you think sponsors find the most challenging?
If you're a sponsor, if you're not a lawyer and you don't work in this full time, then there's no doubt that the volume of guidance and the volume of rules that you're expected to be conversant with is in many cases prohibitive. If you're a busy HR director or global mobility professional, there's no way that you'd have time to be across all of the obligations. So, and that's actually something that's in many ways got a problem that's got worse in the last 10 years, I would say. In 2012, I checked just before this call, there was 900 pages of rules. Now it's up to 1,400, which doesn't sound like a massive percentage increase, but bearing in mind that there's actually fewer routes available, the law has become longer. And the volume of the guidance, I don't have stats on that, but if you look on the old UKBA website, just the size of the guidance is much smaller back then, 15 years ago. It's now very, very large. So immigration is often not front and centre. The person managing the license might be an HR professional. They've got many other things to think about other than immigration compliance. And so it's easy to make a mistake. And it's quite difficult often to communicate with the Home Office to understand what it is, whether what you've done, how to solve the problem you've got. And the license itself is if you look at the case law, to summarize it kind of very to simplify it quite a lot. So that the license is essentially the gift of the Secretary of State. They can decide to take it away and have very limited limits on their discretion to revoke a license. There's a very extensive range of circumstances in the sponsor license guidance in which they can revoke or cancel a license. And even short of cancelling a license, they can simply refuse to allocate more COS, more certificate of sponsorships to a sponsor. And so there's various levels of control. So there's a very significant power imbalance and a very large volume of guidance to contend with. So I think those are two of the things, just very broadly. And then there's also sort of now with the well, it's always been a problem. Before 2021, there was a problem of inflation of roles in which you wanted to sponsor someone who was useful, but perhaps their role wasn't RQF 6 plus, but nevertheless might be very useful role and very important to fulfill within the business. So there will be a motivation to exaggerate the skill level of a role to bring it to make it eligible for sponsorship. Now that problem's gone away, but then there's an issue in the other direction with that because you have to pay at least the 50th percentile for paying that occupation, it creates an equal pay issue because in order to sponsor someone, they have to be paid at least 50 percentile for pay in that sector, but that might not necessarily cohere with pay in that for that role in that company. And there's never been, generally speaking, employment lawyers will say that there's no obligation to sponsor, but the law in that is not completely straightforward. And there's some employment lawyers will say that there's a discrimination element or risk of discrimination claim if you don't sponsor a worker when they're eligible to be sponsored. So that was a slightly rambling answer, but essentially volume of guidance, strength of power imbalance with Home Office, and then a confusing potentially interaction with other areas of consideration for HR professionals.
Thank you. Now, in your experience, what aspects of the application process do you think employees find the most challenging?
Well, for immigration lawyers, for HR personnel or global mobility professionals, and even more so for immigration lawyers, it's very easy to forget that for the person applying for their visa extension, in most cases, it's one of the most important things that they're doing, and it's extremely emotionally taxing, and a lot depends on it. If you're required to leave the UK, if you can't extend your visa, that means that your spouse might need to leave their job, and your children might need to leave the schooling, and your entire course of your life will be significantly disrupted. So it's extremely nerve-wracking, and so even any respect in which certainty can be achieved is very, very good. And it's good that we have a system that is fairly objective in the UK, that doesn't depend on the discretion of an official to agree or not that the job is sufficiently important. It's simply the main determinant is what is the rate of pay, and so that's something that can be objectively assessed. That's something that is an issue, and then there's always just a problem of I suppose that's a gate. That's a sort of segue into many issues that one could talk about. But there's uncertainty about how to complete the forms. There's uncertainty about how long the process will take, and all of that contributes to the impact on the individual concerned.
Are you happy with the processing times?
Generally speaking, as I said, I think the UK actually compares pretty favourably. I think that the business immigration components of the Home Office have generally a professional attitude and are generally quite efficient. And again, it's just a question of money. I mean, if your budget is unlimited, you can make an application for a skilled worker visa. And if really money is no object, you can walk into a premium processing centre in New York and have your application processed in extremely short order, much quicker than would be possible in other countries. So yeah, I would say I'm generally happy with processing times, subject to the visa, that it's a question of how much the individual can afford to pay.
In your role with skilled worker applications, do you arrange to collect the data from the sponsors and the job applicants and fill in the UKVI forms?
Yeah, so generally, one has to collect the data from them to complete the application form. I mean, I think is your question about whether they submit the form directly or the representative collects it first and then inputs it to the government web form?
It's more a case of, do you do it yourself, the data collection, or do you outsource it to other other departments, or do you have
So
in-house
I
solutions?
think
I'm
every
just sort of
firm is
curious.
very different, but generally speaking, everyone is looking for a way to make that process as efficient as possible. And clearly, the skills involved in assessing someone's options and advising them on perhaps an edge case are very different and more advanced than filling out a form. So one is always looking for a way to delegate that function.
What are your expectations for the future of the skilled worker scheme? Do you think it'll continue in its current form, or do you envisage some changes?
Yeah, I mean, well, it's a to some extent a political question. I don't know what the development of immigration policy will be, but in terms of direction of travel, as I say, self-sponsorship routes to move to the UK or to be in the UK as a foreign national have largely been closed down or made so difficult to use that the volumes compared to pre-reform are absolutely tiny. So almost always the direction of travel has been towards the work permit route, skilled worker, as being really the only way into the UK for business migration. And so that's been the direction of travel since I've been in business immigration in 2015, and it doesn't seem like that's had any risk of stopping. The UK economy clearly needs, in the sense that there is clearly a demand for migrant labour within the UK economy for skilled work, and that's not going to go anyway anytime soon. And so I expect there to continue to be a very large number of skilled worker demand for skilled worker visas, even with the increase to the 50th percentile.
How do you stay up to date with changing rules and policies?
Well, I'm always reading the law. I mean, I don't really stop. So I listen to podcasts. I read blogs. I subscribe here to Lexis. And we're constantly discussing new cases, interesting scenarios, and really hardly a day goes by that I don't learn something new. And so that's something about immigration law that's always quite refreshing. I mean, it doesn't seem like the most difficult in the sense that we're not dealing with highly sophisticated financial instruments, derivatives or something. But on the other hand, actually, each situation is so unique and the rules are changing so quickly. You actually have to be reasonably intellectually nimble in the end to always get it right. So it's just a constant process of reading and listening. A very generic answer. I mean, sort of concretely, I listen to the Free Movement podcast, I read the blog, go to open meetings, speak to other professionals. I'm very pleased that Vanessa Ganguin got a good number of sort of boffins, I would say. It's lots of lively discussions about points of law.
Well, I know, Alex, you're a fantastic collaborator. Certainly, in my experience, we've often asked each other questions and had very sort of what I would call in-depth discussions. And I think, Vanessa, the firm you've joined, it has a fantastic reputation. Well done. I read her blogs with enthusiasm, and I think you've made a great move, and I hope it goes well.
Thanks.
Okay, well, thank you. And do you have a question that you would like me to pose to the next person I interview, which is probably going to be the fellow I mentioned earlier?
Is this a politician potentially?
Yes, I'm scheduled to interview him on Thursday.
This is just off the top of my head. I mean, I'd be interested to maybe something around. I wonder what they think the obligations of citizenship are. I mean, if you were planning to broach that subject, and why there's citizenship obligations specifically, as opposed to obligations that might give rise to civil or criminal liability.
Are you thinking of obligations
what
from
sort
which
of
to...
scope of things that constitute citizenship obligations as opposed to other types of obligations? There's obligations.
Just to be clear, are you thinking in terms of obligations upon the citizen?
Yeah.
All right, Alex, thank you, and I'll finish at this point.
Thanks very much.